And I now invite the chairperson of the committee, the Section 194 Committee, Honorable Richard Gyangi.
Honorable Speaker, the Deputy President of the Republic, members of the Executive, members of Parliament, members of the media, fellow South Africans, to echo the words of the Constitutional Court, the National Assembly and by extension Parliament is the embodiment of the centuries-old dreams and legitimate aspirations of all of our people. It is the voice of all South Africans, especially the poor, the voiceless, and the least remembered. It is the watchdog of state resources, the enforcer of fiscal discipline, and cost effectiveness for common good of all of our people. It also bears the responsibility to play an oversight role over the executive and state organs and ensure that constitutional and statutory obligations are properly executed. Parliament is the mouthpiece, the eyes and the service delivery ensuring machinery of the people. No doubt, it is an irreplaceable feature of good governance in South Africa. The public project is established by Section 181A of the Constitution as one of the institutions set up for a very important purpose of supporting and strengthening our democracy. The Constitution, in unambiguous terms, provides that the public protector is independent and subject only to the Constitution and the law, and it must be impartial and exercise its powers and perform its functions without fear, favor, or prejudice. Moreover, the Constitution enjoins organs of state through legislative and other measures to assist and protect the public protector, to ensure its independence, impartiality, dignity, and effectiveness. The public protector, like other Chapter 9 institutions, is accountable to the National Assembly. Accountability is the cornerstone upon which the Constitution is built. It is the pillar that drives our constitutional dispensation. Accountability, together with the responsiveness and openness, are the cornerstones of our democracy. And all of these values entrench a culture of justification and explanation of one's actions. The Supreme Court of Appeal explained, to ensure a functional, accountable, constitutional democracy, the drafters of our Constitution place limits on the exercise of power. Institutions and office bearers must work within the law and must be accountable. Put simply, ours is a government of laws and not of men or women. The committee thus found itself in an unenviable position, one that every South African would hope is never repeated, where it had to hold to account the very person appointed to investigate impropriety and improper conduct in state affairs. The charges against Advocate Mkhwebane, based on the grounds of misconduct and incompetence, were serious and related largely to matters in which all South Africans have an interest and which impacted us all. These included alleged misconduct in respect of the reports of the South African Reserve Bank and the Free Dairy Project. In addition, there were serious charges alleging misconduct and/or incompetence and relating to the management of internal capacity and resources in the PBSA, the prevention of fruitless and wasteful and/or unauthorized expenditure in legal costs, failure to conduct investigations independently and impartially, and/or deliberately avoiding making findings against or directing remedial action against certain public officials while deliberately reaching conclusions of unlawful conduct and imposing far-reaching remedial action in respect of other officials. After the former speaker determined that the motion was in order, it was referred to an independent panel for a preliminary assessment. The panel comprised of the retired Judge Kabinde, Advocate Tsebenza SC, Advocate Deval SC, who conducted this preliminary assessment. On 16 March 2021, this House agreed to conduct an inquiry into Advocate Mkhwebane's fitness to hold office. on the grounds specified in the motion. Since the dawn of democracy, this committee is the biggest committee ever to have been established, with each of the 14 represented parties in the National Assembly having voting power. This speaks to the importance and interest in the matter we're charged with. The inquiry was embarked upon without a blueprint or precedent to guide us, but we're unanimous in our understanding that our role entailed a fact-finding exercise to establish the veracity of the charges contained in the motion and whether those facts establish misconduct or incompetence as defined. We place no blind reliance on the report of the independent panel, aware of the limitations of that body. We are at all times acutely aware that the committee had to discharge its function with reference to its constitutional purpose by providing this House with sufficient information to determine whether the grounds as alleged have been established. I have no doubt that the committee has established on the facts that Advocate Mkhwebane has indeed misconducted herself and is incompetent. She is therefore not fit for this esteemed office which she has been entrusted. Indeed, our report is detailed and described with reference to the facts that we adduced why this is the case. Ours is not an inquiry which rubber-stamped the findings of the independent panel or the courts. On the contrary, we had hundreds of hours of testimony and were seized with copious documentary evidence. Where we have established misconduct or incompetence, we are confident that Advocate Mkhwebane did not raise any valid defense for a conduct to sway us. In fact, the inquiry unearthed even further examples of misconduct and incompetence that, had this committee not adduced evidence in the manner that it did, would never have come to the fore. The committee proceedings were guided by the rules of this National Assembly, our terms of reference, the directives issued by myself as chairperson, powers, privileges, immunities of Parliament and Provincial Legislative Act of 2004, but most importantly, the supreme law of the land, the Constitution. The committee process was inquisitorial in nature. We agreed to utilize the services of evidence leaders to assist and empower us by presenting evidence and putting questions to Advocate Mkhwebane. From the onset of the inquiry, Advocate Mkhwebane indicated that she was participating under protest, but was eager for a version of events to be heard by the public. But as it were, the committee was denied the opportunity to hear direct oral evidence due to circumstances beyond its control. She never answered the many questions which the committee put to her on the substance of the matters before us, instead adopting an adversarial approach where she maintained that the process has been inherently and irreparably unfair and biased and the outcome predetermined. The committee dealt with several procedural objections and was faced with various obstacles which interrupted and affected our ability to carry out our work. Indeed, the journey was not easy. There were many off-ramps, but we soldiered on, determined to fulfill our constitutional obligation and not to be held to ransom. I have no doubt that the committee has carried out its functions diligently, despite all of these challenges and attempts to frustrate the process. 24 witnesses presented evidence. Advocate Mkhwebane herself, her own written evidence. This was considered by the committee together with the many sworn affidavits. The committee conducted a lengthy and legally sound process, which focused on fact-finding in a manner that was fair to all. The committee called witnesses and was presented with evidence in addition to the judgments, which contained serious adverse findings against Advocate Mkhwebane. Had any such predetermined outcome existed, the committee would surely not have plowed the time, financial and human resources into understanding the role of the public protector, the manner in which she investigated. We did not arrive at these findings lightly, and what the public and fellow members of the Assembly may not have seen was the hours and hours of diligent and consistent work that took place behind the scenes to try to unpack the charges. The drafters of the Constitution allocated the responsibility of making these findings in respect of the removal to a committee of the NA. We are confident that Advocate Mkhwebane was not denied the opportunity to be legally represented as she claims. To the contrary, the committee used its best endeavors to assist her to have access to a stated legal advice. This process culminated in a report which shows incontrovertible evidence that Advocate Mkhwebane has misconducted herself and is incompetent. Thus, notwithstanding the noise that has surrounded the work of this committee, the cries of unfairness of being a predetermined outcome of this being a political campaign to protect untouchables, what rings crystal clear through all of this and what cannot be denied is that Advocate Mkhwebane, on the facts established, is not fit and proper to hold the high office of Public Protector. The success of our work has been made possible by honourable members of that committee who are robust and committed to duty, the evidence leaders, Parliamentary Constitutional Affairs Office, entire support staff, the media covering our work, each of the 24 witnesses, the independent panel for their work. Most importantly, we thank the members of the South African public. The work we do in holding those that will public accountable is not always easy, but we persevered, steadfast in our commitment to you, our people. We believe that we have executed our duties to the best of our abilities. Where we have fallen short, we will learn from it. I have no doubt that this process will forever be recorded in the history books of our nation as a reminder to every person who performs a public function that you are accountable for your actions. With humility, herewith, I table this to this august House, the report of the Ad hoc Committee of Section 194, for your consideration. I thank you.
Thank you, Honourable Gyanji, for the report. Honourable members, I now invite the Honourable Dr. A.T. Laureate.
Speaker, in a 2016 matter, the Constitutional Court expressed itself by saying, "The Public Protector is thus one of the most invaluable constitutional gifts to our nation in the fight against corruption, unlawful enrichment, prejudice and impropriety in state affairs, and for the betterment of good governance." And I agree, Speaker. The office of the Public Protector is one of the most invaluable gifts to our nation. But provided that the incumbent to that office lives up to and complies with a set of values, principles and requirements required of a public protector. But let's look at what is expected and required of a public protector, as very well summarized by Mr. Hassan Ibrahim when he appeared before the Section 194 Committee. At the very least, the Public Protector must meet the constitutional requirement of being fit and proper as an objective requirement. The Public Protector must be beyond reproach, a person of stature and suitably qualified, acting with dedication and capable of maintaining high standards. The Public Protector should be conscientious and have the integrity required to be entrusted with the responsibilities of the Office of the Public Protector and to discharge the substantial constitutional duties and obligations. Added to this, the Public Protector must exercise functions with actual and demonstrable independence, impartiality, dignity and effectiveness. What is also important that the Public Protector must maintain credibility, scrupulous honesty and personal integrity. Openness and transparency should be part of the office and how it operates, and it should always work in good faith. But very importantly, Speaker, at all times, the Public Protector must not put personal interest over and above the public interest, and not put personal interest above those of the Office of the Public Protector and the mandate of the office. This is a very high bar set, and the incumbent whose responsibility is to give effect to it. Speaker, it is this Parliament's responsibility to ensure that the Public Protector lives up to this, and that the Office of the Public Protector, this invaluable gift to our nation, is protected. It is therefore a seminal point in our democracy today, where Parliament is requested to express itself on the fitness of the incumbent Public Protector to hold this esteemed office. Yes, it is a first for Parliament, but at the same time, it is an indictment that it was allowed to come to this point. However, as the National Assembly, we can today give effect to what the writers of our Constitution had in mind when the office was created as a Chapter 9 institution. Speaker, it was more than a year-long process to get to the point today. It was a year where the NA had to develop new rules and directives to give effect to Section 194 of the Constitution. It was a year in which the committee and the public were exposed to every trick and tactic in the Stalingrad Handbook. A year in which court case upon court case was launched to stymie the work of the committee, and where the courts found again and again in favour of the committee and Parliament. It was a year in which committee members, the chairperson, evidence leaders, and above all the witnesses were exposed to insults, attacks, threats, and a total disregard for the dignity of Parliament and its processes by the Public Protector and her legal team. This is not what our citizens deserve. Not only were the actions and behaviour we all had to witness beyond any level of dignity and decorum, but it was a reckless abuse of taxpayers' money. Millions upon millions wasted by the Public Protector and her team on frivolous and irrelevant arguments and witnesses called, as well as the never-ending demand for postponements. In fact, Speaker, it all amounts to a staggering 160 million rand if you add all the cost orders and the legal costs, money we won't get back. Although we had the opportunity as the NA to develop new rules and directives, we have to, as a lesson learned from this episode, obtain clarity on what is reasonable legal assistance. What does it mean, and what is the extent to which taxpayers' money can be used for such purposes? It cannot be an open-ended, unlimited and unfettered right and provision. It is also to understand that the individual, the incumbents, must be separated from that of the office. And Speaker, if I have to be honest, if we look at what we experienced, the evidence that we've heard, it is clear, without a doubt, that Advocate Mkhwebane cannot proceed as the Public Protector. We can correct the situation. We can protect the office of the Public Protector. We can ensure that the citizens of South Africa are protected from an incumbent who does not comply with the high bar set for the Public Protector. And Speaker, we can again do it, not only today, but also to ensure in future that we do not find ourselves in this situation by not heeding when concerns are raised about a possible incumbent. So, Speaker, today we can change history, we can correct the wrong by supporting the removal of Advocate Mkhwebane. Thank you.
I thank you, Honourable Dr. Lodley. The next speaker is Honourable OMC Mautwe.
Thank you very much, Speaker. Speaker, myself and the President of the EFF participated in this process from its inception. The President of the EFF would have been here to participate in this debate if he was not persecuted by the alliance of the ANC and the white right-wingers who have now forced him to appear in court on frivolous charges. The report we are required to endorse today is a product of a process that has been grossly unfair to the Public Protector and which has been nothing more than a vindictive political witch hunt against the PP. As the old English saying goes, in matters of conscience, the law of majority does not work. Here today, Speaker, the uninformed majority seeks to railroad all of us to impeach a person not liked by the establishment. Here today, we see Parliament being used to break the law in order to protect the powerful. This report was hurried and ignored basic principles of fairness that are normal and ought not to be negotiated in a process such as this one. It is a clear demonstration of the determination of the chairperson to move with speed to impeach the PP regardless of the litany of procedural mishaps committed by the committee since inception. The hurried nature in which this report has been prepared lays credence to the view held by the PP that this is a frivolous political process meant to punish a person who is not compliant with the dominant narrative which seeks to uphold or hold up the current head of state as a saint. Apart from the many procedural own goals, Speaker, by the chairperson and the committee, the most important issue at the moment is that the PP has not had legal representation in the committee since the termination of the funding for illegal fees by the acting PP since the end of March. The acting PP's belated offering of a 4 million rand has been mired in controversy, which has not allowed the public protector space to have legal representation. Firstly, the acting PP indicated that Advocate Mkhwebane must appoint her legal representative herself and manage the additional 4 million that the office of the PP made available as she wishes. This was unheard of and placed the PP in a very precarious position because she is here to account for her performance as the PP and not as a private individual. Secondly, this committee railroaded the PP to have the state attorney as the attorney of record. This was done despite the PP having raised concerns about the conflict of interest of the state attorney. This was disregarded by the committee again, further exposing the PP to a state-sanctioned witch hunt whose figurehead has always been the chairperson. When the PP finally managed to appoint Chinese attorneys, the committee refused to give them time to acquaint themselves with the record. On what basis were the attorneys going to brief counsel if they themselves did not have an opportunity to study the record and get to know the case? Chairperson, Speaker, Rule 129 AD requires that this committee must conduct its proceedings in a reasonable and procedurally fair manner. We can never claim that the conduct of the chair was reasonable or fair in the manner he has handled this issue. From the initial directives that the chairperson issued right up to the end, this process has been grossly unfair to the PP. The findings in the report that the PP demonstrated incompetence in relation to the charges against what she faced were therefore predetermined. This is the mandate that the chairperson and the evidence leaders were given, and these findings were made without affording the PP with her constitutionally enshrined rights to legal representation. The fact that the report mentioned that the process will be moved after the term of this PP expires in October is proof enough that this process is no longer about justice, but about punishing an individual. Parliament can be reduced to a tool for punishing individual who seeks to disagree with the powerful. We therefore reject the report and we reject the political witch hunt initiated by the DA and supported by the ANC alliance to punish Advocate Mkhwebane in order to protect Mr. Ramaphosa. We reiterate our stance as the EFF that we reserve our right to take this report and the illegal adoption of this report by this Parliament on judicial review, and we invite all interested parties to join us in doing so, including Advocate Mkhwebane herself and all justice-loving individuals in this country. I thank you.